Bergren Tree Fruits LLC applied to Chelan County for a planned development and major subdivision located on over 40 acres of former orchard land. Following a review under the State Environmental Policy Act, a mitigated determination of non-significance was issued. The project could go ahead. Nick and Melissa Rossi owned an orchard nearby and appealed the review conclusion, arguing the hearing examiner's findings were inadequate, the project did not comply with the urban growth plan, and they stated there were multiple SEPA violations. Let's take a look at the arguments.
Again, good morning. This is Washington State Court of Appeals, Division 3. We're convening this morning to listen to oral argument in Rossi Larson LLC and others versus Chelan County and others. My name is George Fearing. I will be presiding over the hearing today. With me on the court panel today is Judges Rebecca Pinnell and John Cooney. Judge Pinnell is by Zoom from her chambers. Judge Cooney and myself are present in the courtroom, and the courtroom is open to the public. I see that Ms. Hurst and Mr. Bricklin are present, and I believe both of you represent the appellants. Is that correct?
Correct, Your Honor. And I'll be providing the oral argument.
Thank you. And Mr. Bricklin, how much time would you like to reserve?
Say 6 minutes. It's 15 total, right?
Correct.
Yeah, 6 minutes.
Thank you. And Mr. Foster is here on behalf of Chelan County, is that correct?
Correct, Your Honor.
And Mr. Gatens is here on behalf of Bergren Tree Fruit, the other respondent, is that correct?
That's correct, Your Honor.
How does the respondents intend to divide their time?
Well, Your Honor, I'd like to have 5 minutes and reserve the rest to Mr. Gatens.
And you'll go first, Mr. Foster?
Yes.
Okay, thank you. I will not be checking to make sure you stay within your 5 minutes, so I'll leave that up to you. And you'll have a total of 15 minutes. So we will proceed with Mr. Bricklin. Please proceed, Mr. Bricklin.
Thank you, Your Honor. Government agencies are responsible to serve their constituents, to follow the law, to follow correct procedure. We recognize Chelan County may not have the resources of a King County or even Spokane County, but they're better off than some of the smaller counties in Eastern Washington. And in any event, resources are not, that it's no excuse for not complying with your own code. We also understand that agencies don't like to deny permits. They sometimes view the development community as their customers to be served. They're concerned about takings claims. But the agencies are responsible to the public too, to follow the law, to provide this court with adequate findings and conclusions so that the court can evaluate the agency's efforts. Our briefing here, I think, has provided you a pretty clear picture of a county that has not met its requirements. The hearing examiner made very little effort to provide this court with a reasonable record to be reviewed. The hearing examiner basically cut and paste conclusions provided to him by staff. There was you're unable to discern from those findings how the hearing examiner weighed the evidence and reached the findings and conclusions that he did.
Mr. Bricklin?
Yes.
What permits, if any, had Chelan County issued for the proposed project by the time of the hearing examiner's hearing?
None. This was the site development permit for this project. Nothing preceded this.
Is Rossi Larson only appealing the mitigated non-significant determination under SEPA?
No, there's two challenges. One is that one, and the other is to the permit. So the permit is what's sometimes in SEPA parlance referred to as the underlying decision. And the SEPA, yeah, I'm sorry.
And the permit from the state as opposed to the county?
No, there's no state permit involved here. It's just a county permit.
What permit did the county issue?
It's a site plan approval.
Please proceed.
Yes. And first, with regard to the adequacy of the findings, there's a preliminary objection been made by the respondents that LUPA doesn't call out as one of the grounds for review whether the findings are adequate, but it's basically implicit. And I would point out that in the Citizens versus Chelan County case, another case involving the same county, 20 years ago, this court decided a case based on the lack of adequate findings in the LUPA setting.
Mr.
And so moving beyond that,
Mr. Bricklin, Judge Cooney is attempting to ask a question and he needs to go through my computer. So
I'll just a little bit, Mr. Bergren. It's unclear. Are you also challenging the adequacy of the findings on the conditional approval or just on the SEPA issue?
both.
Okay.
And really, I mean, the way this is structured, the SEPA is not a permit or an approval. SEPA is an environmental review process that an agency has to go through before they make substantive permit decisions. And the agency documents its environmental review process through various documents. If the agency decides it's not going to prepare an environmental impact statement, it documents that decision in a determination of non-significance. And that decision not to prepare an EIS can be challenged. That's what has happened here. And then, but regardless of what level of environmental review they do, once that is done, they then have to make a decision on the permit itself. And that is, again, in the SEPA parlance, that's referred to as the underlying permit. That's the substantive permit decision that we are challenging, as well as the county's failure to do an environmental impact statement. And the mitigation is, so when a county decides not to prepare an EIS, sometimes they say, well, the reason we won't require you to do an EIS is we're going to require you to adopt this mitigation. And those SEPA mitigation conditions as part of the SEPA review process then get carried over and put into the permit. So the permit allows them to actually do whatever it is they want to do. And the permit includes conditions, some of which often are conditions that are carried over from the SEPA review process. So our first concern, as I say, is about the adequacy of the findings. And they are very conclusory. As in the Citizens versus Chelan County case, it's basically a cut and paste by the hearing examiner of the findings that had been put together by staff. And you simply can't figure out, frankly, how the examiner reached the conclusions that he did. And we went through a number of examples in our brief. I'm just going to mention one here very, very quickly because time is short. But one of the issues, for instance, was regarding the viability of the drainage plan and whether certain the area that was set aside for dispersing the stormwater was going to be adequate or not. And our expert demonstrated that they hadn't done any calculations. There was no sizing, there was no diagrams, nothing to show that this was actually feasible, and that the Department of Ecology suggested it wasn't an appropriate technique in this setting. And in response, the county provided no expert testimony. The applicant provided no expert testimony. And so the hearing examiner has all this evidence on one side that it's not adequate, nothing from the other side. And then the examiner enters findings. You would expect, if he's going to rule against us, to explain what his thinking was as to why this testimony from our expert didn't move him. And it's just not there. He just, all he does is, he doesn't discuss the substance of the testimony at all. And there's no clue as to how he weighed the evidence. And so that's just one of many examples. And Bergren's response was really a non sequitur, frankly. He says, well, Bergren says, well, there'll be more review of stormwater issues later. That doesn't explain the basis for the examiner rejecting our expert's testimony that this system isn't feasible. Feasibility has to be determined at this stage. You can't, that's the whole purpose of this permit is this a feasible site plan? Sure, later on, you'll figure out, what size, the pipe's going to be 10 inches or 12 inches, what kind of, are the grates going to be 6 inches apart or whatever, all those details come later. This stage is this a feasible plan? Because after this approval, the applicant is allowed to go in and tear up the land. You go in there, you do your grading, your clearing, fill, you put in the roads, you put in the utilities. So even though it's considered a preliminary approval, it's highly consequential. And that's why the code requires that the basic feasibility of the project, of the site plan, be determined at this stage.
Mr. Bergren, can you tie your concerns about the lack of findings to legal errors that are the basis for our appeal?
Yes, and so we went through in our brief a number of factual issues that had to be determined. For instance, this one that I just mentioned, is the stormwater feasible? Is stormwater drainage plan feasible? That's a required component of the site plan review. And and we presented evidence that it wasn't feasible. And if it's not feasible, the permit was issued in error. You cannot issue this site plan approval if there's not a feasible plan in place for dealing with the stormwater.
And that's part of the county code?
Yes, that's part of the county code. And that's true with any number of issues that we raised regarding the lack of feasible evidence that this project was feasible.
Mr. Bergren, your
yes.
Initial time has expired. I don't know if you want to fully answer Judge Pinnell's questions before we move on to the respondents.
I'll stop at that point with just to finish that one sentence. The other examples we had, they don't have an adequate plan regarding the contamination, about land use conflicts, about traffic. All of these things were required findings by the hearing examiner per the code that he didn't make. And I'll reserve the rest of my time. Thank you.
Thank you. Mr. Foster, please proceed.
Thank you. As I said, I'd like to only take about 5 minutes here. The county would like to cover two issues primarily. Those issues are the adequacy of the hearing examiner's findings and the specific issue of the agricultural review committee that was brought up by the appellants in this case.
Mr. Foster, since you're addressing that topic, let me ask you, is a hearing examiner's finding that he deems one party's expert more credible than another party's expert a sufficient finding when the hearing examiner does not provide any details as to why he believes one expert is more credible than the other?
Yes, I think that he's had the opportunity to review the credibility of the witness. I don't think he needs to necessarily go into detail. He has a significant amount of record to look into. So I think it is sufficient, yes.
Can you cite to any case law that says that such a finding is sufficient?
I don't know of any case law particularly on point. I would point out that as to the adequacy of the findings, I think the appellant here is misstating Citizens v. Chelan County. That case had to do with a board decision in Chelan County that didn't even address the actual question. So the question before the court was not whether there were adequate findings. It's whether they even address the question at all. And so that was the primary finding of the court. And so I think, yes, in this case, there were adequate findings. There was significant testimony. He had the opportunity to ask questions of the experts, and the record reflects that. So I think there is adequacy here under the standards. And one of the issues that Mr. Bricklin brings up is he says that review of the adequacy of these findings is a prerequisite to LUPA. I think the question for the court is in the LUPA context, whether there was one of the standards was under 3670C 131 was met by the appellant, and I think the correct standard of review is it would arguably be subsection A, where they have the burden of proving the hearing examiner engaged in an unlawful procedure by issuing inadequate findings. But again, I think we don't have that issue in this case. So under the standard of Weyerhaeuser that was brought up by the appellants as well, that was an extreme case of noncompliance, in the words of the other citizens case cited by the county and by Bergren. So the hearing examiner's findings are adequate because they considered the evidence. He made credibility determinations, and that was a large basis of what his decision was. In the particular case of the stormwater issue, Mr. Bricklin did not point out that Public Works reviewed initial stormwater plan. The engineer for the county reviewed that plan that was in the application before the hearing examiner. And so he made a determination that the information there was more credible and sufficient for the purposes of the project than the expert brought up by Mr. Bricklin. And I think that Bergren makes a good point when they say that in many ways the adequacy arguments being made by the appellant are in fact asking this court in a way to reweigh the evidence, and that's not the court's job in this case. It's to review for substantial evidence, and there's significant deference given to the decision maker, the county, and to the hearing examiner in this case. Now, very briefly, the one thing I'd like to point out is the Agricultural Review Committee. As we pointed out, that committee was never actually constituted. And if you look at CCC 1030, it's not a mandatory statute. There's no clear, it does not specify what types of applications would be reviewed or what criteria would be used to decide if a specific application might involve agricultural mitigation issues. It would only be empowered to make recommendations and wouldn't have any binding authority. So for these reasons, I think the findings are inadequate, and it was not an error of the hearing examiner to find that the not reviewing by the Agricultural Review Committee was correct in the case of this application. So I'd reserve the rest of my time to Mr. Gatens.
Please proceed, Mr. Gatens.
Thank you, and good afternoon or good morning, Your Honors. I'm going to jump right back into this issue of adequacy of the findings, and specifically what the hearing examiner's decisions did in regard to some of these very specific elements. Respectfully, I think Mr. Bricklin misstates the record and the decisions themselves with regard to something like stormwater. The reviewing standard there is whether there's substantial evidence in the context of the plan PD application, and under SEPA, whether there was a clearly erroneous determination. For stormwater, the hearing examiner did weigh competing experts and simply found that Rossi's expert was not convincing, and that's at Clerk's paper 1627. Moreover, much of Rossi's arguments about stormwaters are based on theoretical speculative impacts, things that have not happened, but the conditions of approval, which are extensive, there's over 66 of them, require that for final plat approval, that there has to be compliance with the county codes, the Department of Ecology, and all of the state standards. And that's at CP 1627. Another example would be traffic, Your Honors. That's a SEPA threshold determination. Again, the standard would be clearly erroneous. In this particular case, the record shows that there were multiple iterations of traffic studies, and that ultimately the hearing examiner, over the course of a multi-day hearing process where the hearing examiner effectively cross-examined both lay witnesses and expert witnesses, the hearing examiner found that Rossi's expert was not convincing because of a lack of data. And that's at CP 1627. Specifically, he found that the Rossi's expert had not visited the site, but instead had just interviewed neighbors. Compare that to Bergren's expert, who did multiple site visits, did those site visits during harvest and peak travel times, and ultimately put those into a report that the hearing examiner, at his discretion, appropriately found to be more compelling. And then also, in the context of traffic, he conditioned the final plat approval on the installation of 2 offsite major road improvements, and that's at CP 47. When they complain of a general non-compliance with the comp plan, I think that is also very easily and demonstrably false. The comp plan policy A, at its outset, says that when an agricultural owner of property decides that they want to change their property to a more urban use, in this case residential, that the rationale is within the UGA, when the owner of existing ag parcels decides to change the use of their property to a more urban land use, the community will support and encourage landowners to develop the land according to the designations of the comprehensive plan. That's exactly what the Bergrens are doing. This project property is slated as some of the first property in the Peshastin UGA to convert to this type of use. Now, Rossi alleges that the hearing examiner didn't appropriately or address conflicts between agricultural use and urban uses or residential uses. First off, the comp plan is a roadmap to how these areas are going to develop. It is not a planning document. It's not prescriptive that way. It recognizes that there will be conflicts between uses, in this case, ag and residential, and the hearing examiner appropriately recognized that and put into his decisions specific requirements that address very specifically conflicts between ag and residential use. For example, he requires that the plat of the property have a notation on it that it tells all future owners that there's adjacent ag uses and that those are allowed to continue under Washington State's Right to Farm Act. There's a plat condition that homeowners have to control noxious weeds so that they don't impact neighboring adjacent agriculture uses. And then, of course, there's traffic improvements that are going to facilitate not just the new residential uses, but are going to improve the traffic flow for the agricultural uses. So it's not accurate to say that the comp plan's recognition of conflicts wasn't addressed by the hearing examiner, as another example. A further example, Your Honors, is an attack on the model remedy that was adopted for use of cleanup of soils. This is former ag land, and so it's identified as having lead and arsenic. The Department of Ecology's interim director, Jeff Neuschwander, submitted testimony in this matter that the DOE's model cleanup program for former ag lands was not just appropriate, but necessary for this specific site. In contrast, the Rossi's expert said she had no familiarity with the model remedy, but she just didn't believe that it would be carried out. Appropriately, the hearing examiner found the Department of Ecology and their subject matter expertise in this area to be much more compelling than the Rossi's expert. And that can all be found at CP 1241. Further examples, they complained that the hearing examiner didn't appropriately condition open space, but the hearing examiner did, and the disagreement was whether the open space could be contiguous or not vis-a-vis trails in the Chelan County Code, that specifically at 1122-0503B1 allows trails to create contiguous usable space. That's in the hearing examiner's findings. There's arguments between the parties about if the hearing examiner correctly did density calculations for the project, and the findings on that issue are pretty clear. The hearing examiner found that when you do the math, that there are allowed to be 5 units per acre if you're doing single family homes, and you're allowed to have 10 units per acre if you're doing duplexes. Now, The Rossi's counter and say, well, but if every single family residence had an ADU or an accessory dwelling unit under that theoretical assumption that you would somehow breach the single family 1 unit per 5 acres designation. But there's two problems with that. The first is, once again, whether they agree with what the hearing examiner did isn't the analysis. The question is, did he do the analysis in his decisions? And he very clearly did. And to the extent that Chelan County Code doesn't create a difference between, or define, ADUs different than duplexes in the context of this density calculation, it's ambiguous. And that ambiguity was resolved by the hearing examiner when he approved the density sought. And that deserves deference from this court to that hearing examiner. Another issue that they raise is that they say the hearing examiner erred by not requiring 100-foot setbacks to adjacent properties. But the problem is that 100-foot setback is for commercial ag zones, or the AC zone. This property is zoned R1, which is a residential zoning. It is not an AC or commercial ag zoning. And in fact, there is no AC zoning anywhere within the Peshastin UGA. And I point these out to your honors because these are examples that speak to this larger issue of whether the hearing examiner's decision, both with respect to the PD application, as well as the underlying SEPA decision, are sufficient in their findings. And the answer is yes, they're extensive. It was a multi-day hearing. Agency comments were considered. Public comments were considered. Expert testimony was taken. The hearing examiner, like I had said, acted effectively as cross-examination, eliciting opinions and thoughts from these experts. And in his decision, he says, I found this one to be more credible, and says the reason why. Ultimately, your honors, I think what's going on here is that the Rossis fundamentally disagree with the zoning of the property as R1 or residential. But that decision was made by the legislative body for Chelan County, which is the Chelan County Commissioners, when they adopted the comp plan and for the Peshastin UGA. And Washington case law is very clear that you cannot use a challenge to a specific project to challenge a county's zoning designations. And that case is Woods v. Kittitas County, 163 Win 2nd, 597. So in closing, your honors, I want to end with what's the reviewing lens? What's the standard of review here? What must Rossi convince this court of? They must convince the court that there's just simply no substantial evidence in the record for the hearing examiner's extensive findings. They can't do that. The hearing examiner is given deference in his opinions. In the context of SEPA, they would have to be able to show that his decisions were clearly erroneous and unfounded in the law in any way. And they can't make that showing. His findings are complete, his findings are thoughtful, and they address and defeat the issues that are raised by Rossi. Thank you, your honors.
Mr. Bricklin?
Yes, to go back to a question asked when I was up before, the code section that lays out the requirements for a plan develop, I refer to it as a site plan approval. The language of the code actually is a plan development approval. It involves a binding site plan. In any event, code section is 11-22-050 is where the requirements are. Sub 6 and other subsections there provide some of that detail. I thought it was very telling a minute ago where counsel said the examiner made a determination as to that our experts weren't credible and explained why. I agree with the first part of that statement. The examiner said, for instance, Ms. Saltanovich was not credible. Did he say why? No. And that was a flat misstatement by counsel. That's exactly why this court can't determine what the basis for that finding was. You know, if he had said Ms. Saltanovich was not credible because she lacked the necessary training, because she hadn't done a site visit, because she provided inconsistent statements, because she didn't have any documents to back up her testimony, then there'd be some basis for understanding why he discredited her testimony. And the other point here is there was no contrary expert. This wasn't her versus another testifying expert from the county or the applicant. So it was baffling that without any critique of her testimony by any other expert, he just said, oh, she's not credible. End of analysis, and end of my educating the court and the parties as to the basis for that.
Okay, Mr. Bricklin,
yes.
Let's assume there's a bench trial in an automobile accident case. The trial court's obligated under one of the civil rules to enter findings of fact. And let's assume that the trial court finds that the defendant had the red light and the plaintiff had the green light, and the court says in the findings the plaintiff is more credible than the defendant. Is that a sufficient finding to find that plaintiff had the green light and the defendant had the red light, or does the trial court have to explain the reasons why he or she finds the plaintiff more credible?
I think if the case is turning on the credibility, yes, I think the appellate court, and I'm talking to you, to an appellate judge, so it's your call, but I would think an appellate court that was reviewing a decision would want to know what that was based on, especially if there was no indication from the evidence that the witness wasn't credible. If counsel could point to any indication from the cross-examination or otherwise that Ms. Saltanovich or our other experts weren't credible, then maybe the findings don't need to elaborate. But there's nothing in the record. They haven't cited anything that suggests that she wasn't credible. The examiner didn't cite anything. And the other thing, I don't want to get too hung up on the credibility. Other findings were inadequate that had nothing to do with credibility. And we recited all those in this in our brief. Counsel talked about the density, and I just want to touch on that briefly. This is not a theoretical concern, as he put it. This approval authorizes density as we have calculated it, and this is not an issue of an ambiguous ordinance. We've laid out this in detail in our brief, but there's a difference between a duplex, which is a second dwelling inside a structure, a single structure with two dwelling units in it. That's a duplex. An ADU is a second structure on the same lot, one house and then a second house on a single lot. And the code is unambiguous that the duplex counts as a second dwelling unit, and yet the density is limited to the number of structures. You can only have 5 structures per acre. And so if you put 2 units in one structure, that's fine. But if you create a second unit on that one lot, that's not fine. And there's no ambiguity in the code, and we've laid that out.
Okay, your time has expired, Mr. Bricklin. Thank you, counsel, for your presentation. Mr. Gatens, I see your hand is up, but your time has expired. You're free
One
to
point on the direct statement that I made a misstatement.
You're free to send a letter later if you think it's necessary, citing the record where I think that's what you want to do. At this point, the case is submitted.
Following these arguments, the court found no error in the hearing examiner's decision and affirmed. Should neighboring property owners and land use be given greater consideration in cases such as this? Let me know what you think in the comments below. And if you like this video, please hit subscribe for new arguments every week. Until next time.